Family dynamics and the distribution of inheritance can often become quite messy and emotionally charged, especially when significant assets and legacies are involved. This is particularly true when a will surfaces that seems questionable or gives rise to suspicion. The validity and fairness of the document may come under intense scrutiny. Imagine a scenario where a loved one's will unexpectedly allocates the entire estate to someone completely outside the family, perhaps a stranger or a distant acquaintance. Or perhaps the signature on the will appears inconsistent with the deceased's known signature, raising concerns about potential forgery or undue influence. Challenging a will isn't simply about expressing disappointment or sour grapes over an unfavorable outcome. Instead, it's a legal process aimed at ensuring that the true and authentic wishes of the deceased are ultimately respected and carried out. In Nigeria, the legal framework specifies that only individuals with a direct and demonstrable financial interest in the estate, such as legally recognized spouses, direct descendants like children, or individuals explicitly named as beneficiaries within the will itself, are legally entitled to formally challenge the validity of a will in court. Therefore, if you are a direct heir or a potential beneficiary, and your rightful inheritance or expected share of the estate is negatively impacted by a will that you genuinely believe to be questionable or invalid, you possess the legal right to formally contest the will and seek a fair resolution through the appropriate legal channels. The legal provisions are unequivocally clear on this matter, stipulating that only those with a legitimate stake in the outcome are permitted to step forward and initiate a challenge. This crucial safeguard is in place to protect rightful heirs and beneficiaries from being unjustly deprived of their due inheritance, particularly in situations where a will may have been created or executed under suspicious or fraudulent circumstances. When considering challenging a will, it's crucial to understand that you need solid legal grounds. It's not enough to simply disagree with the contents of the will or feel that you deserve more. The law requires specific reasons and evidence to support your challenge, to challenge a will. These grounds are the foundation upon which your case will be built. Without them, your challenge is unlikely to succeed. Lack of testamentary capacity is a major one. This refers to the testator's mental ability at the time the will was created. If the person wasn't of sound mind, perhaps due to dementia, a severe illness, or medication, the will may not stand. They must understand they are making a will, the nature of their assets, and who their beneficiaries are. Undue influence is another. This occurs when someone exerts excessive pressure or control over the testator. If someone pressured the deceased into changing their will, perhaps isolating them from family or exploiting a position of trust, that's a red flag. It suggests the will doesn't reflect the testator's true wishes. Fraud and forgery are straightforward. These involve deliberate deception. Fake signatures or lies about the contents of the will, or even the existence of other family members, invalidate a will. These actions demonstrate a clear intent to deceive the court. Finally, if the will wasn't properly signed and witnessed according to the law, it can be thrown out. Strict adherence to legal formalities is essential for a will to be valid. In Nigeria, 2 witnesses must be present when the will is signed. They must also sign the will themselves, attesting that they witnessed the testator's signature. Miss a step, such as the witnesses not being present simultaneously, and the will could be invalid. These rules exist to protect the true wishes of the deceased and ensure that their estate is distributed according to their intentions, free from fraud or coercion. Thinking about challenging a will? It's a significant legal step, and it's crucial to understand the process involved. The first step is to meticulously gather all relevant evidence. This includes medical records that might indicate the deceased's mental state, witness statements from individuals who knew the deceased, and really anything at all that supports your claim that the will is invalid or was executed under questionable circumstances. Next, it's essential to hire a probate lawyer. Challenging a will is definitely not a DIY job. You need expert legal guidance. Your lawyer will then file a caveat, which is a formal notice, at the Probate Registry. This crucial step temporarily pauses the distribution of assets, giving you time to formally challenge the will. Following the caveat, a lawsuit is filed in the High Court, carefully outlining the specific reasons why you believe the will is invalid, whether it's due to undue influence, lack of capacity, or fraud. During the court proceedings, both sides will present their evidence, and this might include testimony from medical experts who can assess the deceased's mental state, or handwriting analysts who can verify the will's authenticity. Be prepared, because the process can be quite long and emotionally taxing, but ultimately, the judge's decision on the matter is final and binding. If the court agrees with your challenge and finds merit in your claim, the existing will is officially declared invalid and unenforceable. The subsequent fate of the estate and its assets then depends on whether there's a previously existing and valid will that can then be put into effect. Remember, the legal process is designed to ensure that only genuine and legitimate claims are properly heard and considered by the court. If the court throws out a will, it's as if it never existed. If there's an older valid will, the court enforces that one. No previous will? The estate is distributed according to Nigerian law, usually to spouse and children. Customary or religious laws may also apply, depending on the deceased's background. The goal is fairness. Either an old will is revived, or the law decides who inherits. Challenging a will resets the process, aiming for a just outcome. Inheritance disputes are tough, but the law is there to protect true intentions.